Good morning, ladies and gentlemen. I assume it's over to me. I'm afraid my Slovenian is not very good. And greetings today from on autumnal Scotland here in Edinburgh. It's a great privilege this morning to be able to speak to you, and I'm only sorry that I can't be with you today. I'd love to have been with you, but circumstances mean I couldn't make it. This morning, I want to talk to you about our journey into open access at the National Library of Scotland. And to help with the translation, because I understand there are translators here, I'm going to be reading from my notes, and I hope you don't mind my Scottish accent. Excuse me a moment till I move to the next slide. Just a moment. So what I want to cover this morning is just a little bit of background about National Library of Scotland, its collections and history. And then I'm going to go on to explain about our copyright risk assessment framework. And this framework helps us navigate complexities in UK copyright and assign rights statements. And then I'll go on to speak about some of my frustrations that I have around open access and trying to promote open access. I'm going to talk about dead white men, non-print legal deposit in the UK and the terrible frustrations I have around that. I will probably skip, for reasons of time, commerce versus open access. And then I'll tell you about the most ridiculous and craziest thing that I've ever heard about copyright in the UK. So first, a little bit about the National Library of Scotland. The National Library of Scotland is Scotland's copyright or legal deposit library, and its main building is in the city centre of Edinburgh, the capital of Scotland. So before the National Library was established by an Act of Parliament in 1925, Scotland's legal deposit library was the Advocates' Library, and that's a law library that is right next door to this library. That library was established in 1689, and from 1710 onwards, it started collecting books under the UK Copyright Act of 1710 and claiming a copy of every book published in the UK. So the Advocates' Library then was the National Library in all but name. But over the centuries, the Advocates' Library filled up with books and they eventually ran out of space. So by the 20th century, something had to be done about that. And that is when the Act of Parliament came and enacted the National Library of Scotland. And also the building and the collection received a generous donation from a man called Sir Alexander Grant. He donated £100,000 so that the collection from the Advocates' Library could come to the nation. And a little known fact about Sir Alexander Grant is he is the man who invented the digestive biscuit. And so we always joke at the library that the foundations of the library are built on top of biscuits. So today, the library's collection is estimated at more than 57 million items, which includes books, manuscripts, maps, newspapers, moving image and sound collections, and all of these are in both physical and digital collections. Now, being the director of digital, I do have to say a few things about those digital collections. So the digital collections now account for more than half of the library's collections, and most of that growth in digital collections has occurred in the past 10 years since the regulation for non-print legal deposit came into force. And as you can see from this slide, the physical collection runs to 26 million items, but there are approximately 30 million digital items. And these are made up mostly of archived websites, non-print legal deposit, ebooks, electronic articles, digitized collections, and purchased digital resources as well. So it's taken us 300 years to grow that physical collection to the size that it is today. But as I said, it's been less it's just been little more than 10 years for us to grow the digital collection. Of course, in 300 years, you learn a lot about how to manage a physical collection, but 10 years to manage a digital collection, that's no time at all. So just a few words about our digitised resources, just to give you a little bit of context before I start to talk about our copyright risk assessment framework. To date, we've digitised, or other organisations have digitised on our behalf, more than 600,000 works. And the majority of these are out of copyright works, and we have applied open rights statements to these works. It's impossible for us to know how these out of copyright works are being used and reused by people, or what impact they're having on people's lives. But we do see our digitised works on Wikipedia, people's blogs, and in books. And sometimes we see them on television as well. And as I said, we have rights statements assigned, open rights statements assigned to these resources. But often still people still ask permissions to use these resources. And of course, we advise them that they may be used for any purpose, for putting in books or for commercial purposes as well. Just one comment about some of these works. While some of them are, well, they're out of copyright, many have contractual restrictions applied to them that limits their use. So I'd like to explain a little bit about our copyright risk assessment framework now. So given the scale of our digitisation activities, where we digitise thousands of film and video, audio, maps, books and manuscripts every year, we need to be really consistent and accurate as possible when assessing and assigning the rights and permissions to these materials as we publish them online. And really, to be honest, we've not been, in the past, we've not been as good at that as we should have been, and we've not been as consistent as we might have been as well. And that inconsistency in our approach has occurred for a couple of reasons. Firstly, the complexity in the UK copyright law. It can be really challenging to interpret that law and determine if works in different formats are in or out of copyright. It's quite a difficult legal act for librarians and archivists to get their head around. And second, our internal processes have led to inconsistency. We have many curators in the past attempting to work out what the rights are on work that they want to digitize. And again, with so many curators looking at that, not being expert in copyright, then inconsistencies start to creep in. So we recognized that we needed to support and guide staff in assessing rights in the materials that they were planning to digitize. And in 2018, we developed and implemented our copyright risk assessment framework. And this framework allows anyone in the library to make consistent, justifiable and rational decisions about the copyright status of any materials. The framework was developed by our Rights and Information Manager, Fred Saunderson, and it was developed in collaboration with colleagues at National Library of Wales. Both Fred and our colleagues at National Library of Wales have professional interest in UK regulations such as copyright and data protection, and they use their expertise to develop the framework. So the framework is both in use here at National Library of Scotland, but also at National Library of Wales. And so we use that framework to help us assess the rights in out of works that we want to digitize. But we also use it to advise users who ask us questions about copyright in the library. So the framework has, in its guidance, it sets out 4 principles, and I just want to talk briefly about those principles. The first principle is that we will not claim fresh protection in works that we digitize. So if we digitize a work that we have assessed is out of copyright and in the public domain, we leave it in the public domain. We don't assign a license that requires attribution to it, and neither do we restrict its use in terms of its commercial reuse. Before we implemented the framework, we would routinely claim protections in out-of-copyright works by assigning Creative Commons licenses such as CC BY. And our second principle is that we will manage the risks associated with publishing digitized resources. So that we are, well, one of our worries is that if we are incorrect or inconsistent or inappropriate assignment of rights, this can bring legal, ethical, and reputational risks to the library. So we use the framework to manage that risk. So legal risks are things like being taken to court. If we breach copyright, you can imagine if we perhaps published part of a Harry Potter book, which are written in Edinburgh, if these are in copyright, we would be hauled up in court very quickly for that. So the framework helps us manage that sort of risk. Also, there are ethical risks, including such things as attempting to claim fresh protections in out-of-copyright works. Like, for example, restricting the commercial use of a work. It's our view in the library that in doing so, trying to claim fresh protections is ethically and morally wrong, and is actually counter to the intent of the UK copyright law. And of course, legal and ethical challenges can lead to reputational damage and reputational risks as well. So the framework, by supporting us in consistently interpreting and applying copyright law, supports us in managing these risks. And our third principle is that there's a clear assessment process. So the framework guides our staff through the process so that they may determine their rights in any work. As a first step, it has staff check publication dates and date ranges. Then it looks at whether there are named authors and asks questions about their birth and death dates. And then it looks at the different types of work. So for example, if it's a government publication that is in Crown copyright in the UK, its copyright period is shorter than the other works at just 50 years. Or perhaps another kind of work might be a film which has very complex and interlinked copyright protections. So after assessing a work, the framework will outline its risk level for publication. It will advise on the appropriate rights statement to use, and also advise if additional permissions need to be sought. So that's a very brief overview of the process, but it's much more complex than new and nuanced than I've just explained. And our fourth principle is that we will use consistent rights statements. And we use rights statements from the website www.rightsstatements.org. And these statements are a suite of statements that are designed for cultural heritage organisations to communicate about the copyright and reuse status of digital objects. And it was Europeana and the Digital Public Library of America that established the Rights Statements website. So just want to touch on the benefits that we've seen from implementing our framework. The first thing we found is that staff spend much less time trying to work out the intricacies of copyright. And they just follow the framework and its process and its logic. And they also no longer need to try and work out what the rights statements are, because again, the framework will assist them in assigning the rights and permissions. And Fred, our rights and information manager, spends much less time supporting staff with their copyright queries. So we've seen great benefit from it in that instance. So I just want to show you here an image from our digital gallery. And we can see here that we are now using these consistent rights statements. So this item here is a digitized work from our project with Europeana Sport. This item is from 1921. It's been assessed to be out of copyright and with limited risk. So we have asserted that this item is in the public domain and people may use it as they wish. Another benefit of our framework and our consistent use of rights statements and our ambition to be as open as possible within the constraints of the law, of course, are that we've developed new services and collaborations. This here is our data foundry, and our data foundry is the library's platform for open data collections. And here we make available open collections in machine readable form. Our data foundry includes digitized resources. So this includes the images themselves and their associated descriptive metadata, all of these from our digitized collections. And we also include within these digitized resources on the data foundry, their OCR, their optical character recognition, if it's available. And we wrap all of this information, the images and the data, up in METS and Alto XML files. We also share on Data Foundry our descriptive metadata collections. So this is the metadata about some of our resources. And we make that available in Mark XML and Dublin Core. And we're working at the moment to try and make it available as CSV as well. We include also in the Foundry map and geospatial data from our maps collections, and also organizational data such as financial information. Data Foundry is managed and promoted by our digital scholarship librarian, Sarah Ames, and the data in it has been used by researchers in their projects. As I said, it's very popular, the Data Foundry with researchers, and it's been used quite extensively for a range of work. This example here is about the digitized editions of Encyclopedia Britannica. We've digitized 8 editions of that encyclopedia, and our colleagues at the University of Edinburgh have used data science techniques to process the collection and get insights to the growth of content and knowledge over the years. The collections have also been used to generate works of art, data visualizations, and to support crowdsourcing projects. And just by way of a quick example about how the framework and the consistent use of rights statements has supported reuse of our collections. Here is an image of a photograph of the construction in 1887 of the Forth Bridge. This bridge is a UNESCO World Heritage Site that crosses the Firth of Forth, a major river that's just north of Edinburgh. So the library digitized the volume containing these photographs and assessed that they were out of copyright. Following the principle of not claiming fresh publications, the library made these photographs available in the public domain. We then loaded these photographs up onto Wikicommons, the Wikimedia platform for images and video, and someone has then taken those photographs and made them available in the Wikipedia article about the Forth Bridge. So this is a great example of how when we place things in the public domain, then we can make them available for reuse in other resources. I now want to talk about my frustrations, about the consequences of attempting open access and out of copyright works and trying to make these works openly available. I want to start, firstly, with dead white men. So here are some of the literary giants from Scotland. On the left here is Robert Louis Stevenson, the renowned author of Treasure Island and Kidnapped. In the middle, our national bard, and we believe, of course, the greatest poet of all time, Robert Burns, the author of Auld Lang Syne, the song which we all sing all over the world at New Year. And on the right, James Clerk Maxwell, whose theory of electromagnetism laid the groundwork for modern physics, relativity, and quantum mechanics. Of course, these men died in the 18th and 19th centuries, and all their works are in the public domain. At the library, we have digitized works by or about these men and have made them openly available. And we choose to digitize these works not only because these men are widely recognized for their contribution to science and literature, but also because there is little risk to the library in digitizing and publishing their out of copyright works. So our digitization decisions in the past, such as digitizing Robert Burns' published poems and manuscripts, have been done with the very best of intentions of making our collections more generally available for use and research. But now we are beginning to wonder if this is in fact the right stuff to digitize. Because given the age of these out of copyright works and the times from which they emanate, where, for example, authors, women authors were not as prominent as they are now, my library and other libraries are presenting to users and researchers mostly works by dead white men. This is wholly not representative of our society then or now, and in continuing to digitize such resources, I believe that libraries are perpetuating the bias that not only white men had or have something to say. The voices of women, people of colour, the LGBTQ community, Indigenous peoples, their languages and cultures are little heard, and as a result, there is limited access to their views and work to read and use for research. So please don't get me wrong, I'm not doubting the greatness of these dead white men, but in our digitization, I believe we must strive to be more representative, more diverse, and more ambitious. We must not be lazy and only digitize out of copyright works because they are easy and cheap and carry no risk to the library in their publication. So we've started to make some modest headway recently in making our digitized collections more representative. Now, when a collection comes forward for digitization, our Equalities, Diversity and Inclusion Manager will assess that collection in terms of its equalities impact. So we make a judge about how diverse that digitization would be. And most recently, we've made progress as part of our collaboration in the Europeana Sport project, where we actively sought to digitize and rights clear a number of in-copyright publications so that we could include works from underrepresented groups. This example here on the left of Asian women in sport was published in 1990, and it's in copyright, as you can see from its statement. However, we've cleared the rights sufficiently so that we may publish it on our website. And on the right is a Gaelic work, which is also in copyright, but similarly, we have cleared the copyright with the copyright owners, and it's now licensed as CC BY. My next frustration is non-print legal deposit, and I've put grrr, because there are so many things that are so frustrating about legal deposit, but I just want to touch on one just now. A quick recap of UK legal deposit first, though. So legal deposit has been law in Britain since 1662, requiring publishers to deposit books. In 2013, the Legal Deposit Libraries non-prints regulation came into force, and that requires publishers to deposit either print or digital resources in a legal deposit library. Those libraries must then make them available on the premises of the library only. And the regulation also enables archiving of UK websites. Now, it's the websites, the archiving of UK websites that I want to touch on here with my frustration. This is really annoying. This really does my head in. So here is an example of a UK website which may, under non-print legal deposit regulation, be archived by legal deposit libraries. This website, legislation.gov.uk, is a UK government website which hosts and provides access to all UK, Scottish and Welsh legislation. And you'll see in my example here that the page we're looking at is in fact the page about the regulation, the non-print legal deposit regulation itself. So when we harvest this site under the regulation, we suck up all the content from the site, process it, and then make it discoverable via the UK Web Archive Service. You might notice down in the corner here is a license statement. So in the UK, like many countries, legislation and other outputs of government are made available under an open license. And in the UK, this is called the Open Government License. And you can see here that under the license, people are free to use and adapt the information for commercial and non-commercial use. So here we have a UK website which is openly licensed and which may be harvested and archived under the UK non-print legal deposit regulation. But that regulation only permits access to the archived version of this website on the premises of a legal deposit library. So this is conflict and conundrum and confusion. So the non-print legal deposit regulation is exerting controls over an openly licensed resource, which is entirely inappropriate to the intention of the open license on that resource. Now, I think this has happened because the basis on which the non-print legal deposit regulation was founded is that of traditional print commercial publishing industry, where open licensing at the time that this legislation was drafted, open licensing, it was of little consideration at that time. So this is really frustrating. Something that is open is then locked down. So at the National Library, we attempt where possible to work around the regulation. And we contact publishers such as the Scottish Government, which also uses an open government licence, and ask permission to archive their website and then openly publish that content. And many publishers agree to this, recognising the limitation of the regulation and the benefits of the library preserving and giving access to their content in perpetuity. So just for time, I'm going to skip over commerce versus open, but what I was going to talk about here was when commercial companies seek out libraries to help them digitize works. And then often when libraries have open licenses, those commercial companies want to retain some rights in the material. But just for time, I will skip over that. So the last thing I want to talk to before I finish up is like the craziest thing, the craziest thing I ever learned about copyright. Tonight, after dinner, I have been advised of my sentence. I am to be executed like a criminal at 8 in the morning. This is the last letter of Mary, Queen of Scots, and it was written on the 8th of February in 1587. She's writing to her brother-in-law about Queen Elizabeth I of England's plan to have her executed in the morning for reasons of treason. So this letter was written in the 16th century. And in UK copyright law, this letter is in copyright. So it's like 400 years old and it's still in copyright. Now, I'm a librarian and trained in everything bibliographic, and so I don't understand a lot about archives and manuscripts, but I cannot get my head around the fact that this item remains in copyright under UK copyright law until 2039. And no one can really explain this to me very, very well. So it's like a crazy thing, absurd, but it's the law. But regardless, rest assured that Mary, Queen of Scots' last letter has been risk assessed by the library, and we determine that it is low risk in terms of that someone may come along and claim rights in it, but still we assign a copyright statement to it. And that statement is in copyright, unknown or unlocatable rights holder. However, in the unlikely event of a rights holder coming forward to claim copyright in this item, then we would apply our takedown policy and remove the content from our website. So we wait to hear from Mary, Queen of Scots descendants about this one. And so with that absurdity in copyright, I'd like to thank you for your time, and I will leave you now, and I'll be happy to take any questions if there is time for that. Thank you very much.